The word reconstruction.
12 and 13.
The Lordships, out of 7,000 beneficiaries, 4,000 funds have been disbursed to them for reconstructing their houses, Your Lordships. So funds are being given to these persons to reconstruct.
The proposal to the state's commitment for reconstruction of tribal villages which were destroyed has also been specifically mentioned to the Government of India scheme providing rupees 5 lakh for Kacha house, rupees 7 lakh for semi-Pakka house, and rupees 10 lakh for Pakka house. Was referred to on behalf of the authority. Highlighting that a total of 12,000 houses have been approved so far under the PMAYG scheme for affected families. It was also highlighted that 3,000 prefab temporary shelters have been constructed and are currently occupied, and a sum of rupees 51.95 crore was released for 885 identified beneficiaries for construction of permanent houses. In addition, a sum of 1 lakh per household has been provided in installments, is being provided in installments for fully burnt houses. Besides, 75,000 for the partially burnt houses. That's what. It is, however, urged on behalf of some of the affected families that the aforesaid relief is yet to percolate at the ground level, and 300 to 400 families, affected families, are yet to receive the benefit. We are informed that the range of such families have been furnished to the 3-member committee headed by Justice Geeta Mittal, former Chief Justice of the High Court. If that is so, we request the committee to verify the complaint made by the alleged affected families and forward a latest status report regarding implementation of the government welfare scheme duly noticed by this court in the order dated 27th May 2026.
Lordships, there's one aspect.
And my lord, I'll give a list of the houses which I had included. They are in that same state, and not only that.
That you have furnished, but even if
I'll give it, my lord. Yes.
you can give it,
Yes.
if the petitioners come to desire may furnish better particulars to the committee of this committee.
Your Lordships, one aspect which I wanted to bring to
verify that
Lordships notice, Your Lordships, is that with regard to the hilly areas, the law with regard to the lands is not implemented, Your Lordships. So as far as encroachments are concerned, Your Lordships, it is very difficult for us to construct in those areas. In fact, they are occupied by large farming of poppy, etc. So what my learned friend is saying, yes.
File a report.
Yes, Your Lordship. So that aspect we are pointing out in our report.
If the land records are incomplete or
Yes, Your Lordship.
such difficulty, we have already passed a direction. No construction should be allowed at the site.
Yes, Your
The
Lordship.
status quo should be maintained.
Yes, Your Lordships. The 1967 law, Your Lordships, in hilly areas, that, Your Lordships, the government has to implement. That's how, Your Lordships, the reconstruction can happen. That is the biggest roadblock that is being suffered.
Status report so that
We'll
we
do
can
that.
issue direction.
My lord, on a
With your
related
lordship's
point-
permission, your lordship,
On a
I have
related
an
point-
IA. Your
May-
lordship, I have.
Just one.
Sim-
May I move,
IA.
my lord, to the attacks on women? 80 attacks, murder, rape, and mutilation.
So that can be.
I've got the IA,
point
kindly open that,
on
please.
encroachment of.
With your lordship's permission, I had moved an IA, your lordship. It's IA 1942-32-33 of 2014, 2024, sorry. And that is regarding those Kuki people who had to flee from Manipur. They are residing in Delhi, and they have houses in the plain area in Imphal. In Imphal, their houses are there, which have been completely demolished and occupied by encroachers. We have approached the committee. Nothing has happened till date. There is not a single report. And Your Lordship, we've even filed FIRs. There are 0 FIRs which were registered, but till date, nothing has happened. It is still, and we have no information about our own properties, and we are not in a position to go to Imphal and find out about our properties. Today, we
So-
cannot enter.
Yeah. So
And
the
also-
assailants
My
broke,
lord,
We have given it, Your Lordship,
Yeah.
along with our complaints. So what do we do, Your Lordship? We have no place to go.
so the assailants,
Main number is.
they broke the house and today they
190.
occupy the house.
That is SLP. Yes, yes, Your Lordship. That is in SLP Civil 19206 of 6.14.
If there are particulars in your IA, please
Yes, Your
give a copy of that to Madam Viva so that it can be referred to the committee and the direction which we have issued that cover your application.
Your Lordship, yes, some report may be given on the status of our properties as well.
In this regard, the committee may also verify the amendments made in IA number 7. So a copy hereof has been supplied to Madam Viva Datta, representing the committee.
That's an idea, item 6.1.
It's SLP or IA?
My lord, item
IA in an
6.11,
I'll give the.
Just a moment, I've
which
not,
pertains to.
yeah, why I've not finished. Then, my lord, the same order of Justice Chandrachud says 227 churches burnt to the ground will be reconstructed, not one. That's the second point on this issue. Then I'll come to the attack on women.
Before,
That is-
if I may just add to that. I
Yes,
also
this
have a
was
list
raised
of
before your
the-
lordships on the last
have a
occasion
list
also.
of,
Your lordships have requested them to
churches.
go to the committee. They have submitted the representation on Friday. That's what Ms. Makija is saying.
That's
The
exactly right.
committee will give a report.
That's
Mala.
exactly right, but I just want to
And your
say
lordship
that,
saw in the previous report, the focus was on dwelling houses first and then all religious places.
That's
It can't be
understandable.
identified as a particular religious place.
I'm on a separate point.
Lordships,
Uh,
that's
there are
what I
two
conveyed
lists.
to your lordships, that our primary focus was on rehabilitation, construction of houses, the prefab houses, your lordships, the displaced persons to come back into the state. Now, as far as the religious places are concerned, your lordships, Ms. Alam has given that list of properties, your lordships, and this was given to me only on Friday, your lordships. So we will look into it and report to your lordships.
That's the one, lordships, but
We'll
there
report
are two issues.
Yes, yes.
Yes,
There
no, my lord.
are two
It's
issues
come
there.
only on Friday to me, your
There are
lordships.
two separate lists. That's understandable, but I'm just pointing out that there are two lists. One is a list of 276 places of worship, which needs to be verified. Our claims need to be verified. The other is a much shorter list of 20 churches where there's active encroachment. And out of those, 5 or 6 are such that if fencing is allowed immediately, then encroachment will stop.
So the last location made it clear that where enforcement already taken place,
So
may
we'll-
take some time,
We leave that aside,
Yes.
Lordship.
but
5 or 6 are such.
committee would take your concerns into consideration and ensure that there is no further encroachment of the churches.
If that could be
Lordships,
done
they
in a
can give us
time-bound
a
manner,
comprehensive
Lordship.
list, because they keep repeating the same properties over and over
They are
again, your lordships.
experiencing some difficulty because of that land record also.
Yes, sir.
This is all verbal now coming today. If there is some report before us, we could direct this state authority. The problem is that please say something in writing, give a report to us.
We filed that also, Lordship.
Now, my
Together
lord,
with
may I
scriptures,
take you
everything.
to,
If-
And records to show to us, your lordship, so that's also a time
But
consuming.
there are 6
activity.
churches where there's no dispute also. If
Lords,
if
Just give
Lordship
us a
will-
comprehensive.
My
list
lord,
with
my
the
request is, my lords may say religious places. Please don't
Lordship-
identify, my
Lordship will
lords.
just have my list, which I filed, with pictures. Lordship will see that if there is immediate fencing, this property will be saved. It's just lying vacant.
Madam, you approached.
They have already passed
we've done
their order.
So Lordship will direct that it
There's
be done in a
already a-
time-bound manner,
Let
because
the committee come before us or give directions upon the local authorities or the state.
that's what I'm
Yes.
praying for.
They give
That's
representation on Friday and on Monday they want orders from your lordships, my
no,
lord.
no,
without
we
the
gave
committee
this a
looking
year
at it.
ago, sir. The persons who broke our houses occupy our houses today. We gave photographs.
Lordships
The
have-
persons who broke are occupying our houses and running clubs and things like that.
Displacement.
I'll
is
give it
across
again, sir.
communities.
No problem, sir. I welcome this.
Displacement is
There
across
are-
I
communities.
welcome this, sir. I welcome this. We'll give it again, full details.
Are being made.
Yes.
You are talking about dwelling houses,
Dwelling houses, yes.
about religious places.
Also, my lord, we're doing both.
Your main focus was on dwelling.
No, my lord, both.
Okay, fine.
Yes,
So for her exclusively religious places.
yes, my lord.
Now, the issue is that so far as dwelling houses are concerned, we've given directions today for the committee to look into the representations
Please.
made of displaced persons,
Please, grateful.
encroached dwelling houses, burned down dwelling houses, and they will give us.
We'll furnish.
Grateful.
So far as the religious places are concerned, there were twin issues. One already encroached, one an apprehension of encroachment. Earlier orders have been passed to direct the state to ensure that there is no apprehension.
Yes.
There should be a injunction on that. And representations were directed to be made before the committee.
Made, my lord, made.
And take necessary remedial measures.
Yes.
We understand on Friday, the representations have been made,
Lord,
identifying certain religious places where there is an imminent threat of encroachment.
six such places.
Six such places. We hope and trust the committee will immediately.
Lordships, we've also received
Communicate
from,
to the committee to take.
from
Lordships, direct
persons
bring
from
them a
other
time-bound
religions,
manner.
your lordships, not just
What we
the
are saying,
churches, your lordships,
Lord,
other persons have also
I did
represented.
hire retired Chief Justice.
Lordship.
And on Friday, you have approached. Why should we as of now give a time-bound direction? We definitely represent, the senior counsel is representing the committee. The committee would
And
definitely.
in any case, we have already showed the
Look
report.
into the urgency of the matter.
Now, my lord, kindly turn to the attack on women.
See now, nothing to be done, and next date we will see.
Grateful, my lord.
Attack on women, my lord.
Grateful, my lord.
The only problem is that
Lordships will give about a month for us to verify these things.
The verification, yes,
verify
Lordship, but the
and then
fencing
submit a
could be
report.
done.
Within a month,
verify their claims and submit
Yes.
a report.
we'll do
For
it.
the
That
fencing,
there is
Lordship.
no further encroachment.
Yes,
on
your lordships.
Direction we have already issued,
There,
but that
please ensure that.
to the question is ultimately possessory rights, title, whatever it is involved.
That's right.
That you need to determine or tell us what is the mechanism to.
I will do that, your lordships.
Grateful.
My lord.
is against the trans organized. And your lordship, this matter has to tagged with a matter which is related to similar thing. Lakshmi Narayan Tripathi
No
was,
corrections are complied with. We have already. You know, to stay.
Item 8 is also a challenge to the 2026 amendment.
Date both.
Lordship, may permit me to serve on the standing council, your lordship. Much of that.
May I please, my lords. My lords, I am here, my lords, in contempt of my lords, order of my lords, 10th of January 25, and my lords, as well as order of this court on 13th of May 25. My lords, what had happened, my lords, I am a complainant, my lords, in an FIR, in which, my lords, the accused have been declared proclaimed offenders, and my lords, and their properties are ought to have been attached, my lords. My lords, but the accused, my lords, are also decree holders in an award, my lords, of more than 30 crore rupees, my lords, in which during the enforcement proceedings, with the consent of the parties, it has been directed that the amount was to be deposited within seven installments of 30 crores, my lords. Thereafter, my lords, I came before this honorable court. My lords, what has happened? My lords, just kindly have page 16 for a moment. Page 16, my lords, para 6. My lord, what my lords had directed is that the best recourse available in our considered opinion is for the investigating, my lords. Yes,
Page 6
yes, my lord.
occurs only upon page 138 and 140 being complied with of the Delhi High Court direction.
Yes, my lord.
The judgment debtor
Yes, my lord.
is going to deposit in terms of the installment directions given.
Yes, my lord.
If the judgment debtor does not deposit the
Yes,
amount apart from one of the awards,
Yes, my lords.
what will the police do? How will the police
lords.
attach it?
My lords, what I'm trying to say, my lords, deliberately to my lords outlaw the orders of this honorable court. The judgment debtor is not depositing the amount so that the persons cannot,
Now, the Delhi
because-
High Court order which asked them to deposit the money, the Delhi High Court order.
Yes, my lords.
The Delhi High Court, it's a breach of the Delhi High Court order.
Yes, my lords, because my lords had passed an order here.
We ask a question to ourselves.
Yes, my lords.
See page 15 and 16.
Yes, my lords.
Is the judgment debtor bound by this direction?
My lords, the judgment debtor is a party before this court.
Maybe a party.
When this direction was passed, judgment debtor was represented here.
Direction.
My lord-
The direction is on the law enforcement agency.
Yes, ma'am.
Please attach an award when the deposit is made.
My lord-
When will the deposit be made? As per direction of Delhi High Court.
My lord-
That being breached, vote before the Delhi High Court.
May I say, my lords, the judgment director was a party here before when this order was passed, and therefore, my lords, in order to the rights of the parties are not taken away, this court was constrained to pass this order that the amount to be deposited, and my lords will also see.
To be deposited. This court said amount if deposited will be attached.
My lords, also one more paragraph, page 14, para 5. My lords had directed that the entire amount to be deposited there.
Mentioning page 14.
Para 5. Yes, my lords. Page 14, para 5. My lords will kindly have it. My lords, the entire amount under the arbitration award is directed to be deposited. Yes, my lords. But that was made absolute. And my lords, in spite of this, the amount has not been deposited. Yes, my lord.
Where is
My
the
lords-
objection?
It's only in para 6.
Therefore, my lords, I don't have any place to go because my lords has.
Just 200 meter away. Well, there is a,
My lords, may I kindly.
in some substance, the order, the breach whereof is alleged was passed by. So the complaint pertains to the breach of order passed by the High Court.
My lords, I cannot go to High Court, my lords, because I'm not a party in those proceedings.
Make yourself a party.
The appropriate recourse for the petition would be to approach the jurisdictional High Court. The liberty of the present proceedings are disposed of.
So grateful.
Garnish.
Lord, at item 10, Lord Justice Bona has appeared in this matter.
So will
Aye.
before the bench in the number.
Yes.
Will
Deep blue.
ask to bench.
Deep Public.
Sir, I'm the petitioner, I'm part in person. consideration of the Navagiranam, that is RKDP project, cannot be satisfied. Questioning that, again, I went for a
They said there is no patta. However, after perusing some other documents which are helping you to prove your title, you were granted the relief. Now, after getting the relief, you went to the High Court citing other 33 persons who, in your belief, are similarly situated. But the High Court said you cannot agitate as a public interest litigation for some people whose title have not been verified. How can it be done at your behest? Or if anybody is aggrieved, they are supposed to make a representation. They can get their relief, like you have got a representation like that. What prevents them when they are authorizing you? What prevented them from approaching the authorities is what the High Court says.
Here,
It's correct, sir.
nobody is foreclosing their right. They have a right, but these rights are individual rights. Everybody's claim may not be identical. Even if it is identical, it is individual claim. They will apply, it will be verified, and if they have, their claims are not settled and they are not granted necessarily, they can always approach the court. Now, for approaching the court, one possible
My lords, item 12, Learned ASG Ms. Bharti is appearing.
My lords, I beg to appear, my lords. In my respectful submission, my lords, this is a classic case, my lords, which is purely and squarely covered in the guidelines and also judgments of your lordships. My lords, with full pension. My lords, the guidelines and the law of your lordships, my lords, is very clear, my lords, on chopping of dead wood, my lords. When compulsory retirement with full
Is she a
pension.
dead wood?
My lords, yes, my lords.
In certain cases, a bit of an over-enthusiastic wood, but not dead wood. You've been giving regularly excellent, very good ACRs last 5 years.
If your officers
That's-
under your eyes are rewarding her with this kind of
Sir,
reports,
you have to see
then how
also
you
the
declare a
ACRs. How
dead
can
wood?
we ignore the ACRs? That's exactly the High Court saying.
My lords, kindly see what are the factors against her. The most important is she has not been promoted
Paragraph
since.
42, the High Court division bench categorized all the factors, one after another, 4.
My lords, in my respectful
SCR,
submission,
adverse comment.
my lords, in my respectful submission,
Each one of them specifically dealt with, madam. We
My lords-
understand she may require counseling.
my lords, when an officer goes as a full
Yes,
pensioner.
we understand, madam. That is not at all appreciated.
So, my lords, with full pension when she is going, my lords, all that we are required to show. Lordships, there is one more aspect. ACRs being, my lords, in our respectful submission, the High Court and the tribunal have misdirected themselves because ACRs, there is, my lords, comments of the highest executive. The Chief Minister and the then LG, the then Chief Minister, made scathing comments. And the High Court says because you've not issued any warning letters. My lords, on the promotion, her entire batch has been promoted. She has not been promoted despite 5 attempts. Since 2019, she's being considered. And now 2 charge sheets, my lords. Absent, my lords, these are senior level administrative officers, my lords. Your lordships have clear time and again said, my lords, that senior officers.
So why don't you charge sheet those officers who have granted the reports?
Lords, my lords, on ACRs, there are comments, my lords. The reports are there, but not all are, my lords, good or outstanding. They are average ACRs and there are strong comments. The High Court only says that you have not issued a warning on the basis of those comments and therefore you can't. My lords, for the purpose of the law is very clear, my lords. For compulsory retirement, the entire dossier is checked. The entire service record we are entitled to check. And my lords, an officer, please see on promotion also. Since 2019, 5 attempts, my lords, 5 DPCs have found her unfit for promotion. She has not challenged her non-empanelment or non-promotion. Her entire batch has been promoted. And my lords, on the 2 charge sheets, one is a charge sheet of minor penalty. The second charge sheet, my lords, though the tribunal had, my lords, had held against us, but the High Court has passed an order. My colleagues are carrying a copy of that. That's an order of April, my lords, where MHA has been found to be the disciplinary authority. So we are proceeding with that charge sheet also.
That we appreciate, but the decision for compulsory retirement was passed at a time when the charge sheet had been quashed.
No, but my lords,
You continue with the charge sheet, right?
my lords, I will be
Now
able to show, I can show the whole dossier to your lordships. Your lordships may look at it. If your lordships don't permit, in a case like this, a senior officer becomes a mere passenger in the administrative services, my lords. And she's been out since 2023. I will, Lordships may, Manoj, consider having, I'll show the entire service record to your Lordships. There is no mana fights here, Manoj.
First, show us the personal book and service book.
I'll show it, Manoj. I'll place it before your Lordships.
Solution of India's switch and guarantee time to produce the service and personal book of the officer.
I'm grateful. I'm very grateful.
Wait, please, Your Lordships. Your Lordships, this does not have to be an adversarial proceeding, Your Lordship. Your Lordships, there's no difficulty with the child being admitted to nursery at all. If your Lordships will mold the relief accordingly, that was never put to the petitioner, Your Lord.
You apply for nursery, we can direct the authorities to consider.
Your Lordships, no difficulty at all. If your Lordships will issue short notice.
Nursery mein ho jaye.
Delay 1 year.
No problem, Your Lordship.
Child
No
will be
difficulty.
It is
In fact,
better.
it may be better for the child, Your
Yes,
Lordship.
yes, it is better, and thankfully she will get better issue.
I'm so grateful, Your Lordship.
Meanwhile, if the petitioner parents apply for admission to, for petitioner's admission to nursery class, put the nursery class.
Your Lordship, nursery,
Pre-KG, is it?
nursery/pre-KG, Your Lordship.
That's called pre-KG.
Pre-KG, Your Lordship.
Pre-KG.
Nursery in bracket pre-K, comma. Such a request shall be favorably considered.
I'm so grateful, Your Lordship. So short returnable date, if I may request.
Up to 1 week then.
I'm so grateful, Your Lordship.
May I please, my lord? My lord, in this case, an 80-year-old lady, my lord, and 2 concurrent finding, my lord, and 50 dates have been spent, my lord. Yes.
To entertain the resolution for such like prayer, comma, liberty is granted to the petitioners to approach the High Court with an application for early hearing.
My lord, already 5.
The petition may also rely upon the health certificate and the necessary bona fide health certificate along with the application. As well, the petitioner who is 81 years old may also rely upon the health certificate along with the application. We request the High Court to consider such application sympathetic.
My lord, already 5 applications have been moved.
We have said now that we consider the application sympathetic.
Obliged, my lord. Any, my lord, time bound can be given 6 months.
May it Lordship.
Notification.
Yes. My Lord, after the recent election, the Bar Council, my Lord, on the Bar Council of Punjab, Haryana, my Lord, constituted the election tribunal on 5th of May. That is annexure 15. And there was an order passed by this court, my Lord, on 18th of May.
Letter has been circulated in this matter, Lordship.
It is not taken on
There
record.
is no adverse orders.
Letter is not on record.
Lordship, actually, in 4th of August, you Lordship passed,
My Lord,
you Lordship, no.
on 18th of May, my Lord.
Lordship, I am petitioner in this matter, your Lordship. Lordship has passed some guideline on 4th of August for a co-opted member, Lordship. Lordship, actually, the order not uploaded till yesterday, Lordship. That's why I need to see the order, what type of guideline my Lordship has been issued. That's why.
I have made, you can inform, that was your petition,
My petition, Lordship.
that earlier.
Earlier also, that was my petition in which Lordship, Lordship.
There is one small change, may not be a small change, but a major change in this sense. We have said that Chief Justice will do it in consultation with the elected members of the State Bar.
But this procedure is very technical also, even though no member, I mean ordinary member like me to approach that members or that Chief Justice Lordship, kindly, when I get it, the order Lordship, then I can make a submission for and prayer for if something is maybe Lordship can intervene that time, Lordship. Kindly give me 4 weeks time for that, Lordship.
That order will be uploaded today. But that was in Yogmaya case.
Yes, Lordship, but that is affected to me also, Lordship.
That
So
is-
that's why I need
That
to
is not the
see.
issue here, my lord. The issue here is only that on 5th of May 2026, Bar Council of Punjab Haryana constitute election tribunal, my lord.
But that is protected by because order says in addition to.
Yes, my lord. Now, despite the fact, my lord has said, Bar Council says that all cases be referred to these tribunals, my lord. Yes, my lord. Yes, now the Bar Council says all the cases.
We don't want to interfere also because that is not the stage to interfere. I understand better, Lordship. Then
It's not about you, it's about the clarification from the
Yes,
applicant.
yes, this is what I'm saying. This is not your case, please.
There is another application by the tribunal.
Yes.
Our order dated 18th May 2026, passed an expedition serial number 589/2026. In para 3, clearly says that inverted commas in addition to the existing election tribunals, inverted commas closed, dash dash, that other tribunals were constituted.
Yes.
It obviously means that the tribunals which have been constituted by the state bar councils will also continue to function.
Please.
Will also continue to function.
That's all.
in MA number 2437, kindly keep it pending, Lordship, because
IA number,
2437.
what is the prayer in that?
In prayer, Lordship, actually, I am not able to approach the tribunal. I
47.
I'm not approaching the tribunal, Lordship, because there were some technical issue. That first it's for a 30,000 for election for filing election petition, and after that every member, as per procedure, every member I need to make a party, Lordship. For that, Lordship, 1,500 is the court fee in that matter. But now the 2347.
Application which you wanted.
Yes, my lord.
The IA which you argued also.
Yes, yes.
47.
MA 2347.
MA 2347.
This application for clarification is by
What we
who?
have now.
By the Bar Council, my lord, by Bar Council of Punjab and Haryana.
In this matter, Lordship, Kumud ma'am will appear in this matter.
The matter was, the petition was filed by you, Madam Savita.
Yes, sir.
But application is by the State Bar Council, only seeking one clarification, whether the tribunal which they have constituted will continue to function. So that we have already protected in the order. We have said in addition to the election tribunals already constituted.
Yes, Lord.
We have simply clarified that yes, that tribunal will also work. Better if there are more than one tribunal, there are 5 tribunals, all election petition will be decided at the earliest.
This is the only clarification.
So that clarification we have made. So nothing survives in that application.
Yes.
But if you want to file any separate application, you can always file. That order is being uploaded today. We have made certain small, not small, but relevant changes in that. We didn't want that elected members should feel as if they have no saying in the nomination of option. So we have added that one line.
Please, my lord.
I am a dispute.
Please. Lord, we have challenged section 21, my lord. Lord, in view of the priority payment given to the
That's one more part.
Item 60. Please, Brian, we have challenged section. Right, we have challenged section 21 in view of the priority payments given to corporation over and above the unpaid depositors notes. No, as on 31/3/2025 notes.
If you have due to hundreds and thousand people, and now you want to take advantage of that.
No, but it's not. What has happened in this case is, my lord, so far as the status of the financial status of the bank is concerned, as on 31/3/2025, it is about 576 crores. Whereas, my lords, whatever the amounts have been disbursed to 20,300
Right. You are representing the depositors,
depositors,
not the bank.
depositors.
And he is the managing director of the bank.
We are the association of the
You are
depositors.
the managing director of the bank.
Please, my lords.
You are the managing.
You are the secretary of the bank.
The secretary of the association, my lord, who of unpaid depositors, my lords.
No.
There were, my lord, about 23,000 depositors have been paid, my lord, 5 lakhs. Now, my lord, those who had more than 5 lakhs, my lords, they have not been paid the amount. They are unpaid depositors, which is their amount is about 9.
If you are representing the interest of the unpaid depositors, then unpaid depositors will also get the same relief from the corporation bank as the other depositors have got.
No, but they are the persons, my lord, whose amount was more than 5 lakhs. As per the policy, they were supposed to give 5 lakhs to each depositors, my lord. They have given 5 lakhs, my lord.
Why this cannot be challenged? Priority to repay is something which is a matter of legislative wisdom.
That's what we challenged before the court, my lord, stating that so far in 1961, my lord, there was an act in which 3 resources was there for funds for this corporation, my lord. One was section 15, which was about premium, my lord. One was section 23, which was interest which they have earned upon the amount of the payment. And the third was section 21, which they said repayment, priority payment, my lord. Now, lord, as of today, in case your lordship may kindly see, I have given the charts which are from the audit report of the corporation, my lord, as on 31/3/2025. At page 82, 83, I have given all the charts, my lord, where, my lord, they get almost about 26,764 crores from section 15 premium, my lord. And they get 15,802 crores from section 23 premium interest, my lord. So far as section 21 is concerned, it's hardly 3%. No, my respectful submission is 1961, when the act was enacted, my lord, empirical data was not available, my lord, at that point of time. Today, that data is available, which your lordships can see. What they earn in 1 year, they have not paid for the entire, from 62 onwards till today, they have not paid that much of premium at all. Even less than that, what they earn in 1 year.
Society has failed to pay, then go for winding up of the society. And if fortunately for you, there are some assets, get them auctioned and recover your amount.
No, but here what has happened is, so far as section 21 of the act is concerned, Lord, we have challenged the constitutional validity of section 21, Lord, stating that, so there are 3 aspects, Lord, which I would like to point out. One, that when section 21(2) priority payment was given to the corporation at that point of time, Lord, empirical data was not available. Today it is available, which according to the audit sheet itself, Lord, they get about 26,000 crores and 15,000 crores, Lord, from the other resources, Lord. Now, so far as this resource is concerned, now in the overall, Lord, 62 years, they have total paid about 476 crores, Lord, so far as this income is concerned, Lord.
it is less than ever even the amount which they get in 1 year from the premium and this thing. Therefore, my respectful submission was before the High Court, which has not been decided, that the provision which might have some reasonableness in 1961, today that reasonableness is not there in view of the fact that corporation can, on its own funds from premium as well as from interest, can perform all their statutory duties as required. But what was the object of the act? That's number one.
To do that, we are enlarging manifest arbitrariness into second guessing the legislative will.
Well, once
If the corporation whose public purpose is to secure small depositors have been given a priority in the matter of realization of their claims against a bank, for which the premiums have already been paid, etc. We do not find any reason that this is completely divorced the legitimate aim and object for which this priority has been given. Priority is not only a matter of insurance. This is more in the nature of securing the economic wherewithal of the weaker sections of society. There are multiple strata of people who go and make deposits in banks. You see, the interest rates may be different for various natures of deposit. So these are classifications which are made, and in this way, if a priority is given, it can't be said to be completely whimsical.
No, but so far as arbitrariness is concerned, your lordships may kindly see prima facie, your lordships can, in case, can see 3 charts which are produced from the art.
This insurance corporation has already made the payment to them.
That is 5
Now
lakhs.
today,
Up to
today
5
you want
lakhs.
to, it will be a very, look at the unfair situation you want to create. They have paid on behalf of the society.
But they are getting premium. All along they have got premium.
Yes.
And that premium they have got on the entire amount, not on 5 lakhs. If I have got 1 crore deposit in the thing, they have got premium on 1 crore, not on the 5 lakhs which they are supposed to pay me. Now, so that they have been getting premium from 1998 all along, my lord, on the entire deposit. And today they have to give me only 5 lakhs. In case the premium was taken on 5 lakhs, then in that case, my lord, probably premium itself would be, this itself would have been. It requires some consideration, my lord, I request my.
I think it requires consideration. You see, you are necessarily entangling the bank. You have a, as far as you are concerned, your claim is against the society. You have a remedy, you avail that remedy and recover your amount.
My remedy, but what I am pointing out to your lordships is that as per their audit report.
Your, the fiduciary relationship is between you and the society. You have deposited your amount with the society. Whatever risk you ran. That's a different issue. Now that your money has not been, is not being paid to you, you file whatever claim against the society.
No,
And if society has any assets, get them auctioned.
Well, so far as, that's what I want to point out to your lordships, my lord. Society's assets as per 31/3/2025 audit sheet is 576 crores. And this recovery they are claiming is about 700 crores. So as it is, there will be nothing. So zero for the unpaid depositors, my lord, who the total amount due for the depositor is about 1934 crores.
Just see the liability which has been shouldered by the corporation because of mismanagement of the society.
No, thereafter, your lordships will kindly keep it.
Society had managed its affairs fairly and properly. The question of repayment of the depositors on a maximum 5 lakh threshold wouldn't have come into being.
That is a body of RBI, my lord. From 98.
For that mismanagement.
But from 98.
What you are trying to do is just the reverse, putting the interest of the big depositors over the interest of the multiple small depositors.
The small depositors have got 5 lakhs, my lord.
Constitutional philosophy.
My lord, small depositors got their 5 lakhs, my lord. Almost 20,000 accounts were closed with that. But my lord, about 8,000 accounts are there in which.
We are not examining your case. We are examining constitutionality.
I understand, Malad,
When
because
the
that's what we have challenged.
constitutionality question comes, we understand the classification from the public good angle. It's not the public good that the big depositors must be protected. Small depositors are to be protected.
Absolutely, but I have not.
And a corporation
that, but
does
my
that.
respectful submission is, Malad,
Giving the advantage of priority of recovery.
Malad,
we
this-
find
my,
no- we
my
find-
respectful submission is, Malad, that from 1998 to 2019, there was every year inspection by RBI, Malad. RBI up to 2019 gave a report that it is absolutely correctly going. There is no fraud, no misappropriation, etc., etc. 2009 up to 2019. It's only in 2019 when the one of the CEO he wrote a letter to the RBI that it's like that he committed suicide also subsequently. That these are the irregularities which have been committed by the society. So that's how. But so far as we are concerned, up to 2019 onward, RBI has given the. Given that this is absolutely going on absolutely correct, audit was done by the RBI, audit was done by the society, the Registrar Cooperative Society.
The primary law was upheld by this court. That the corporation being created under this law
Absolutely.
is valid and constitutionally good. Now the change made is with regard to the priority. And the priority has a rational nexus for the public duty which the corporation is undertaking. Just see the competing claims of 5,000 depositors of 1 lakh and 10 depositors of 20 lakhs. Who is going to be given preference?
Priority is already given. That so far as that priority is concerned, that is not
that
a challenge for your
priority-
lordships, Lord.
Madam, that priority given through the repayment is being balanced by the prioritization of the recovery of the person indemnified.
My
This is
respect-
just a quid pro quo balance.
But once the
Which the
liquidation,
legislature is completely within its competence. to do.
that bank is not yet liquidated, but in case the liquidation
There are
take
two
place,
clauses. A,
there will be-
liquidation. B is of the bank once a direction is given by the RBI under 21A.
let it direct. Is given by the RBI, my lord. That is in 2020, my lord. What that once the directive is given.
Not a case for challenging constitutionality.
That's right.
Working out the claims is another thing.
No, I'm on the arbitrariness of the provision itself, my lord. Manifestly arbitrariness of the provision. Finding out.
Madam, the depositors group you are representing, they can afford loss, not the poor people to whom.
But they're all, my lord, senior citizens, my lord, who have spent,
I'm not saying.
who
Loss
have
is unfortunate.
given their money to the.
Loss is unfortunate, but you are financially presumed to be stable and sound, that you can suffer the loss, but not the poor people to whom some amount has been returned.
I had given, for example, I had given 50 lakhs to the bank. I get 5 lakh. And thereafter, so far as 45 lakhs is concerned, I get nothing.
But the thing
So,
is,
but
please think of the IPC section 53. In a waterfall, what happens?
But I have two more submissions to it. The subject to your lordship's permission. But here what happens is, according to the RBI rules, some 18% of amount will have to be deposited in SLR and 3% in CRR, my lord, which are the all protected investments. Normally 21% out of 100 goes in protected investments. Now, so far as the risk is concerned, that will be only concerning this 79%. But my respectful submission is that so far as the corporation is concerned, they can lay hands on the risk component because it's insurance policies. They are taking premium, not on the secured amounts which have been given, that is which have been deposited with the government as well as bank.
Please don't
So,
ask them
that
what
is
to
an
what has
advice
happened to
that the
council.
bank
No
will
case
take.
to interfere with the implementation of this.
Grateful.
Yeah, Lordship. The question of.
Why don't you challenge 13 to 2026 order in the tribunal?
That is already challenged. In that order, the tribunal has granted a stay to the
execution and implementation of the order dated 13th of February 2024. Against that order, the respondents have preferred the first appeal, and in that, an order is passed.
That is an order of review.
No, that is not an order of review. That is a substantial order passed for accepting the change report of the other side.
13/2/24 is an order passed by the board.
Under section 42 of the Waqf Act.
Passed by the board.
Yes, Your Lordship.
When that order was passed, why didn't you challenge it before the tribunal? Why did you go back to the board?
No, that issue has already come to an end because the tribunal has set aside that order which was passed in the review proceeding and granted me the liberty to challenge that order of 13th of February 24.
That is the 2013 order.
No, Your Lordship.
2013 order allowed the change report in your favor. That was appealed by your opponents. And in that appeal, the tribunal upholds the change order, but set aside the scheme.
Scheme, yes.
Matter goes back before the board.
Correct.
The board incorrectly holds entire order is set aside and accepts the change report of the other side.
Yes, Your Lordship.
Then you approach the board for recalling that order. Where is the power of the board? You should have approached the tribunal against that order.
That's true, Your Lordship. Initially, the petitioners approached to the board, but that
Let us
proceeding.
understand facts first.
Yes, Your Lordship. May I permit?
Yes, now your law election period now is up to election.
No, Your Lordship, kindly, there's a little bit of confusion on the facts. The important thing is that, Lordship, I challenged the order dated 13th of February 2024 before the tribunal, and the tribunal on 10th of February 2026 that stayed the execution and implementation of that order. Against that order, the other side has preferred an appeal in the High Court, and the High Court on 16th of July 2026.
It is coming before the High Court next week, please.
Your Lordship, but yes, Lordship, but the effect is that, Your Lordship, the High Court has directed the Waqf Board to take over the management into its hand.
The High Court has also balanced the rights that no third party right is to be created and no.
But here issue is that, Your Lordship, the injunction has been granted.
So that there is no vacuum, at least in day-to-day functioning.
Your Lordship, we are in management since 2013.
High Court, go and tell the High Court when.
Your Lordship, the High Court has already disposed of the stay petition by passing the impugn order.
We are in actual management.
Of this order is that we have to
They will work out your equities will work out.
Yes.
The thing is that you have no longer a right to continue in management and election has to be held. Correct. But we understand what you are saying, that in 13 your change report was accepted. And in 18 erroneously the board has altered and taken the change report of the other funds.
Yes, Your Lordship. Now, the legality of that order is assailed before the tribunal.
By the other party. You went 26/3, got that state, they came and said, how can you do it? Because there's no power of recall.
This view has been taken by the tribunal.
That is a legal question. But on principles of equity, you are continuing. Let them go and make an application for recalling.
If more application to reconsider.
Because we don't understand how the High Court comes to these findings that there was damage to trust property.
No, this is totally a perverse order.
Sir, with respect, We are giving you the liberty to ask for a recall of this.
Especially petitioner rectification in interim order dated 16 July 2026, passed by the High Court. Regarding, passed by the High Court in terms of ad interim arrangement regarding worker management has been made.
Systems modified, method audit still in it.
Your trustee, ad interim arrangement for the trust property has been made. Till the body of the trustees appointed. It seems to us that the petitioner's main grievance is against the observation made in para 5 the order.
Respondent is permitted to manage, trust property will be damaged.
They therefore permit the petitioners to move an application for modification of the order dated 11 July 2026. And pass appropriate orders so that the elections of the trust can be held fair.
Your Lordship, practical difficulty another is that we have to disburse the salary to the staff. Now, because of this order, we are unable to do it. Let the status quo be ordered to be maintained so that we can disburse that till the first appeal.
That's why we have requested the High Court to consider your application immediately.
And by the time, Your Lordship, the board should not take any coercive action against
So
me.
that would create further complications.
Status quo as of today till my application is heard.
Lordship, I appear for the capital respond number 1.
Your Lordship, one more.
So we have permitted them to move an application before the High Court to recall or modify that.
Please, Your Lordship.
Oblige, Your Lordship.
Thank you.
The sentence comes to be implemented despite your lordship's order and my lords it being taken into consideration by the GCM while my lords giving the sentence. Lordship, may I kindly see the sentencing order by the GCM which takes into consideration your lordship's order. And section 153 specifically says, my lord, that unless and until it's confirmed, it could not be implemented. The Honorable High Court.
Implemented. What about 167?
My lord, but-
72?
My lord,
What about 167, section 167? It comes into effect as soon as the GCM passes the order. The confirming authority only decides whether he will be in civil prison or in military prison.
My lord, but today I'm already.
Prison is sure.
My lords, but today I'm already being sent behind bars and my lords, while sentencing.
You are already in behind bars, sir.
My lord,
You were under the control of your commanding officer, GCM.
Lordship, please.
Now, after the GCM, when you make for a confirmation, it doesn't mean that the sentence or the conviction doesn't operate. It operates from the date of the order of the GCM. Just see 167.
Lordship, please.
It clarifies 153 is to be read with 167.
My lords, 167, my lords, and
Page 72.
72. Yes, my lords, and lordships. Whenever any person is sentenced by a court martial under this act to transportation or imprisonment, the term of his sentence shall, whether it has been revised or not, be reckoned to commence on the day on which the original proceeding were signed by the presiding officer in case of the summary court martial. But my lords, what comes in between 167 is your lordship's order.
Which is order? You're using that order because we were charitable to you and gave that concession. Otherwise, it should have been dismissed.
Which is what, my lords, the sentencing order takes into consideration.
So let it take into consideration. We are fully conscious of what we passed in the order.
Please, minutes. This is a case where, again, 2012. My 17th of August, minutes.
640.
Please, Milods, tag with that. Milods, maybe I may be permitted to serve through the councils already appearing through.
The notice tag with repetition serial number 640/2026. This will be for 17th August 2026. Tag with the repetition number also. Liberty to serve the private respondents through their
Through the councils appearing already. Milods.
Representing, already representing them.
Very deeply,
Respondent for the standing one.
very deeply obliged, Milods.
Leave granted. The permission.
Can I?
IA number so and so allowed. Permission to file appeal is granted. Then say leave granted. Reports be requisition. Post the final appeal. Post the appeal for final hearing. In the month commencing in the week commencing 16th November. Final hearing.
I was impressed with the caveator, my lord. I just.
Once she notice, once you accept notice on behalf, you are for the equity record.
Equity. I just wanted to point out to your lordship, if your lordship, before you.
Granting leave and we are listing the main appeal for final hearing. This matter requires consideration. The accept notice on behalf of the respondent main accused to the government. The complete set of paperwork. Madam, please make sure that it is supplied.
State will have to be served, but they are for private response.
Phone number 2 will also be served 40 days.
CBI. You see.
I thought I should point out that the state has not preferred any appeal.
May not be.
I thought I should bring to your lordship's notice. I thought I should, I thought I should also bring to your lordship's notice that the appeal against an acquittal is a very rare event that will happen. One minute. I also wanted to point out your.
Mr. Vasan, reversal.
Yes, no.
It's a reversal.
It's a case
It's
of
not an acquittal affirmed by the High Court. It's a reversal.
Lordship, the court of facts, the final finding of the court of facts is that I'm entitled to that PW 31 cannot be believed at all.
Exactly what
Yeah.
we will examine the special circumstances attending to the examination of PW 31, whether the appreciation by the High Court was just.
And we are equally conscious of the fact that state might not come in appeal.
My lord, similar issues pending, my lord, writ petition criminal 496/2021. Lordships may issue notice and tag with that. My lord, I read 2 English newspaper and 2 Hindi newspaper daily, my lord. The problem is, my lord, one news is very common. The drug addict kills his father. Drug addict kills his mother.
Very serious, Mr. Upadhyay. The problem is very serious.
Yes, my lord.
Unfortunately, now pan-India.
Yes, my lord.
Some of the states are completely in grip. The others are maybe lesser.
Yes.
Little bit fortunate, but then the way it is spreading in the country. But what is the, you see, coordinated effort, some solution has to be done by the expert agencies and
This is the,
those who are involved in law and order machinery.
my lord, the basic principle is the bhai bin hoy na preet, sathe sathyam samacharit. This is the only. Singapore has done it, my lord. No drug in Singapore, my lord. Totally drug free. Singapore.
Small country, high per capita income. All these things are very relevant, Mr. Fattah. with a international border as India has, you see the golden crescent
Yes.
in Burma and in Afghanistan.
My lord, what is happening? My lord, 2 lakhs unnatural death.
We become the trafficking
Yes,
region
yes.
for drugs.
2 lakh unnatural deaths every year, my lord. 2 lakhs unnatural deaths everywhere due to drug.
Drug havens in neighboring countries, some places, from where it travels from via different countries. Yes. With drug cases in Punjab, they know very well that how drug from a XYZ country comes.
Yes.
Those who dealt with in northeast
Yes.
states,
Yes.
they know how the drug comes from different countries, how it travels. Unfortunately.
6 states, my lord, by Assam, Bihar, Maharashtra. Obliged, man. Obliged.
It's 22, I'm being led by a senior member. She's online appearing to be.
Yes, please.
Mr. Naidu is appearing online.
Online millets. Millets, an investment plan has gone awry and a series of affairs have been registered in different high court, different states millets. Millets, my lords could see at page 7 the details of these FIRs. And millet, there are about 4 states, Telangana, Gujarat, Himachal Pradesh and New Delhi. And millets, 3 of them are in Telangana and all the petitioners accused are in Telangana. And the crime have been registered and they've been arrested. And then millets, the investigation is on.
Crime has been
My humble prayer is
registered,
that
crime was
millets,
committed in different states.
millets, the investment at the rate that they should be getting certain returns. 2 years they could adhere to the plan and they paid back. And there was a run on the company millets. That's why they fell in default. Then the crimes have been registered across.
People have been targeted by you in total.
Beg your lordship's pardon.
In total, on all India basis, pan India, how many people have been targeted by you?
The millets, very few millets. There are 6 FIRs, rather 5 plus 1
7,400.
company.
Your total victims
Millet, they
are
are the investors.
7,400.
Millets, my humble prayer is very limited that all of them could be at one place where because I was arrested in Gujarat, then I got the bail, then there is a PT warrant, then I've been transferred to Telangana.
Mr. Naidu, we are very consistent and you know our views, we don't entertain this kind of prayer. No case to entertain this.
Millets, in one state millets, I could, millets, my lords have held millets that unless special enactments are there, they could be combined in one state millet so that I could face. There is no escape because I've already been arrested as well.
Thank you very much. Thank you.
May it please. Well, your lordship will turn to paragraph 45.115, my lords, of the impugned order. My lords, 45.15 of the impugned order, page 58. Whereas the court says that we are performing a public function, whereas completely the court.
Page 45 or para 45?
But it's 45.15, which is at page 58. Yes.
Yes.
Yeah, and Manoj, the court completely ignores the principles which it itself lays down at 38.3, Manoj. But these are the tests. Manoj, 38.3, Roman 2 and Roman 3, completely, these principles are not even applied.
Are you seriously arguing on maintainability?
Yes, Manoj, I am seriously arguing. And Manoj,
Mental right.
yes. And Manoj, look at the lady.
21.
The lady says,
Swami, I think, sir, and your prayer for not maintainability of writ petition is out of question. Your only argument is one of earlier disclosure.
no, Manoj, apart from the fact, the lady compromises with the father.
We have seen, that's what but the disclosure
And Manoj,
that can be a material consideration in the quantum of compensation.
And Manoj
That it
says that it is a mistake.
Punitive, it should be only
Manoj
token.
says that it is a mistake.
So you should be larger. You
No,
are
Manoj, there are serious implications with this impugned order. But there are going to be writs filed.
Serious implications of sobering you up.
We are a powerful media player. We understand you gracefully should have said, the bona fide mistake it has.
Should have compromised with us.
No, Manoj, that position was, Manoj, I was not even part of it. Manoj, let me just show you, Lordship, that what had happened was we appeared before the court. The court was dismissing it. On 19th April 2012, the court reserved the judgment and closed it. Then, Manoj, on 8th January, just after the Nirbhaya's case, the court reopens it. So, Manoj, this requires reconsideration. Manoj, your Lordship needs consideration of this. Manoj,
What does it require consideration from us? You have nothing to do with opening or reopening of the case. You are only concerned with what is a small attribution.
No, but it's kindly see this. But there are two judgments of your Lordship's court.
What you did might be purely in larger public interest that provision.
Yes.
You might have acted in bona fide. Think it then, going to a victim some amount from your side is not something.
No, Manoj, I am not on the money amount. Manoj, I am not on the point. But Manoj, your Lordship, there is a larger question. Whether I as a press can be said to have performed a public function so that a writ can be entertained. Whereas that is got larger complications.
What does the press do? But for contribute to 19(1)(a?
No, Manoj, would your Lordship just see your Lordship's
Is it
own
not
work?
19(1)(a) a public function?
It should come from your side that you perform a public duty of paramount importance.
Tomorrow your newsprint, when your bandwidth,
yes,
your access to internet will be stopped, you will come saying that fundamental right is breached because 19(1)(a) of the people are being affected. The press is being throttled. And when you make a publication for which you are irresponsible and constitutional tort compensation awarded, you say this is not a public function.
No, Manoj, just your Lordship will just see Basi deity. Manoj, the court says
this argument
it has to be a sovereign function. Manoj, just have a look at that paragraph, Manoj, before 38.
There the judge is wrong. There's a difference between sovereign and public function.
No, Manoj, your Lordship will just see this. The court says, this court says it is 38.2. Manoj, just see page 38.2, Manoj, paragraph 38.2. Para 20, page 28, Manoj, just see this here. And this is what the court says. And Manoj, just have a look at para 28 of this judgment.
Scope has become wider over a period of years. 26, and we see from ZTE,
Goldsha, etc., where 40 years ago.
No, Manoj, just see para 28 of this judgment.
You see, Justice Ravindran's judgment in that cinema hall case, unsolved. There, the compensation awarded for the statutory breach of responsibility. Due care.
No, Manoj, just have a look at para 28 of this.
carry out your functions as per the legislation also. Then also there is a writ maintainable. The state can direct you to do it properly.
No, Manoj, the state can. Here it is against me only.
That's correct.
Now, Manoj, just see para 28.
You are standing on.
But just see para 28. Well, a writ under 226 can lie against the person if it is a statutory body or performs a. But it's several writs are going to be filed. Malaj, I am.
It's a very settled principle, there is no doubt. 28 also reiterates those very principle of scope of 226.
Yes.
But as my brother has pointed out, we are saying that you should rather proudly say that you perform a public duty of paramount importance, that is the guarantee and enforcement of fundamental right of the citizenry of this country. So therefore, rather, why should you feel shy and argue otherwise only as a defense that you don't perform public duty? Government, you should proudly say so.
But let me explain
And
this.
this small token amount, you take it as a donation from your side.
No, but your lordship will consider this. But there are division bench of the Delhi High Court which says that press does not perform that way. But I'm not getting into all of that. But your lordship will see that there are to entertain a writ against me. But let's just have a look at it. But I would be now going through the rigors of 226.
Why not a constitutional court?
And for a case of a
issues pertaining to all those authorities or a person who are having the responsibility to protect, promote, or enforce the fundamental rights.
Kindly consider, there is an Hindustan Times, there is a Star TV, all of them has been exonerated. I have only been.
That is the only thing which weighed with us, that she has pursued the case against you. The reason is, sir, when she requested, she didn't want to join in the publication of the event, you went ahead and published it.
No, Manoj, with the greatest of respect. No, that is not it. Manoj, I did the telecast on the 4th of August. She comes and files a writ petition on 5th of August.
Much earlier. The
Manoj, on 5th of August.
Filed much earlier.
I was not even made a
party as a party respondent later on, because pending that writ petition, you made
the which needs to be decided by your lordship. Your lordship will see this.
No, there's nothing to decide. There's nothing to decide.
But there are issues. The single judge says that the niceties of a trial will decide. But the division bench says no, everything is fine. You will have.
If you want, and that if a prayer comes from your side, we can only say that this amount shall be treated as a small voluntary donation from your side.
No, Maharaj, your lordships may say that it is a donation. I have no problem with that amount. But the problem which I am saying is there is a larger issue. And as
rightly answered by the
you want the larger issue, we'll reiterate the High Court.
Maharaj, there will be floodgates opening because of
It should. We encourage it.
We see no ground to interfere with the influence judgment.
But it's
Wait, please. We are not saying no, bro. We are not saying no, but we want to see the genuineness of the certificate. We want to test what has been stated, whether he actually requires any consultation or not.
Let him go, get himself checked. In the meantime, you start another criminal case if you find that the document is forged.
But there are 16, Maro, there are 16 cases against him. Can't you look at the cases, Maro? There are 16 cases against him. We apprehend that he may not come back. He may not come back. It's an apprehension. But if his medical condition is such, we will not object. But let him get assessed.
I think the state is weighed with much more serious investigation than this. All right.
But this is also a serious investigation, Manoj. There are so many scams. That's a different matter.
You have appeared,
Two things
you
we
have
should consider.
appeared where this individual is involved or alleged to be involved in much graver allegations. And you have not taken any steps against him.
But
So
that's a-
please don't make a situation in this.
But my submission is this, Manoj. If he genuinely requires medical attention, we
That is
last
his
person-
choice.
we'll-
His
we'll the
choice.
last person to object.
Every individual has a right to go abroad. Every individual has a right to choose the medical assistance which.
But we
he
are not
would
saying
avail.
no to this, provided he requires medical assistance.
What you can insist is only the measures to
Yes,
ensure that.
just give us what safeguards you want. In fact,
And he joined investigation and caused no impediment. That's
In
all.
fact,
This is
I'm
what has been passed in
volunteering,
the other
I'm
matter,
volunteering one condition myself, that I have two passports. One is a diplomatic passport for the Operation Sindoor outreach I was sent. I have a diplomatic passport and I have a personal passport. I will deposit my personal passport. Diplomatic passport, the embassies everywhere can keep track of me. I'm offering this as a condition. I don't have to, but I'm offering it.
There's another matter, Manoj, where conditions have been passed. Kindly have a look at this matter. Please can similar conditions.
whatever that matter will be super governed by the order passed by this board.
Yes.
May I have a copy, Mr. Raju?
Yes, ma'am.
I don't know. This is Vijay Madan Lal Chaudhary.
But first is applicant shall file. But this is the matter of.
What is the volume of misappropriation in this case? What is the FIR in your case?
But there are 15 other cases against him. Manoj. Kindly have a look at the case against him.
Criminal case.
But mine,
How can you
Why, even-
compare a member of parliament, general secretary of a
even he
national
was
party?
member of, he is also member of parliament, Manoj.
There's not 45.
But the order that I'm referring to is also member of parliament. Member of
This is
parliament don't get
45 of the
special
PMLA.
We are on the nature of allegations, which is the subject matter of
This-
investigation.
This is an election.
Nature of
speech.
Yeah, there is a lecture given in the course of campaign,
Yes.
which according to the complainant has transgressed the principles of
That is
law.
one thing, but there are 15 other matters pending against him. My lord,
There-
kindly have a list.
In other matters, there's no such injunction on his travel.
Every single one of those were filed after 5th May when the elections were declared. Nothing before 5th May,
That
not
is
one,
because he was all powerful, did not allow the.
not one.
matters to be-
16 FIRs registered after 5th May.
Nobody would have dared register before 5th May, Manoj. But we are not choice. We are only saying,
Okay,
let
okay, sir.
there be an assessment whether he requires treatment. That's all.
Why should
Okay.
we go into?
And when he refuses, Manoj, then adverse influence has to be drawn. There's nothing, Manoj.
Sometimes even treatment for any personal disease or anything, that is also sometimes a part of the right to privacy. But it's not necessary that everything, so it's incidentally, this is a case of an eye, but there may be some other health issue. Why it should be brought sometimes in the public domain also.
And the
That's also
doctor's
a
certificate on
kind of disease.
I'll tell Manoj why.
152,
The
there is
doctor's
one
certificate,
one doctor
which he has relied upon, says CT scan and MRI. He doesn't want to do that. Now, ordinarily, a person with some difficulty will undergo a CT scan and MRI. He doesn't want to do that, therefore.
Dr. Naveen Jaikumar is one of the tops.
Times also.
Pardon.
15 times he has already traveled for this.
Yes, yes.
See, cases were not pending, the lesser, the number of cases now are against. So likelihood of not returning is more today.
6 surgeries. he has
I don't think he's serious about that.
done. 8 surgeries.
With his wife and 2 children in Calcutta, I don't think he's serious about that, apart from being general secretary of a national party.
Right.
I don't think Mr. Raju could possibly be saying.
Who is assisting Mr. Raju in this case, except notice on behalf of the.
Yeah.
When
the Supreme Court argued with that.
I'm ready.
Or this one is on behalf of the appellant and Mr. Raju, an additional solution of on behalf of the appellant. Say you granted. You can say.
Let's see what he says.
No impediments will be, no serious impediments will be caused to the ongoing investigation. Pending against the appellant. if he is permitted to travel abroad for a period of 3 weeks from magistrate 4, for the purpose of the eye surgery. Stroke treatment.
Within 3 days, that he will return to India. Because if he violates that,
Consequently,
contempt of the school.
the appeal is allowed.
For conditions in the order which have passed, but they are innocuous conditions. Kindly have a
No,
look
no,
at the
these are-
conditions in the order which
I
have.
think some reasonable conditions,
They are
of course.
reasonable conditions.
No, no, these are not. Make a deposit of 2
Forget
crores
the
before
deposit part.
Secretary
Forget the
General.
deposit part. Other, my lord, itinerary he has to give, flight details he has to give.
I have a diplomatic passport. I'm traveling on the diplomatic passport.
That doesn't make
You have
any-
control over that.
Basic conditions will have.
Basic conditions, of course, my lord. No, not these.
There is nothing unreasonable about this, except for the deposit. If my lords fail, deposit can be scaled down.
Without the beyond order of the site, and the application and the applicant is permitted to travel abroad for a period of 3 weeks, subject to the following conditions.
In September.
One, the applicant shall deposit his diplomatic passport.
And personal passport. Personal passport.
No, no, I've just gotten later instructions. I understand there's only one passport. There's only the diplomatic passport. There is no personal passport. No, I just was, my instructions have been revised.
We were also.
Yeah, I was under the impression, but
Have to surrender the.
yes. So I was.
Shall give an undertaking by way of affidavit that by way of
He has no
affidavit
other passport.
that he has no other passport.
Yes.
That he has no other passport other than the
Diplomatic passport, yes.
Do I? The applicant shall give itinerary of his visits
Yes.
from a place of residence of the foreign country and the and brief description of the doctor's hospital where treatment will be obtained.
Yes.
The itinerary shall also disclose the date of return as well as along with flight details. The along with flight details and the date of arrival. But just 2 days before the departure.
Undertaking these terms. That's all.
So I just, there's a small problem that it isn't last time. If the agencies will also maintain confidentiality of everything that we are furnishing, our itinerary shouldn't be made public, only for the agency's purpose. They can have it with them.
The authorities may not publish the itinerary that are required to be furnished by the applicant.
People in the flight will know where he's traveling. People
I'm
will
grateful.
know where he is. It's not in our exclusive domain.
From your source, it may not go. He may
Yes.
lose.
Your lordships are disposing of this. Yes, I'm grateful.
Wait, please, your lordships, in this matter, I appear for the state. I request your lordships for 4 more weeks' time. We were directed to.
Let them finally dispose it of from 16 January.
No, I apologize, your lordship. We'll just need 4 weeks' time, that's all. We've,
Say to be,
yes, we've seen your lordship's order in January. We are speaking to the state, your lordships.
state your concern because now there is a.
Yes, change in guard. Yes, your lordship.
And you please convey our sentiments also. We didn't issue a direction.
Yes.
But we expect that the state will honor our.
Yes, your
permissions. And Mr. Vaidyanathan, you should also be liberal.
Yes.
Whatever, whether it is a collector rate or the market rate.
We'll deposit it.
Whichever is higher.
Yeah.
And that's the prerogative of the state.
Yes.
To determine.
Yes, sir.
You see, we don't want that they will determine the price.
Yes, sir.
You determine the price.
Yes.
We don't want to determine.
Most grateful.
But because states will not suffer
Yes.
loss of even a single penny.
Yes, your lordships.
Not even a
That is
single
our
penny.
concern.
If the state needs land, they will provide the land of equal value.
Yes.
If the state as such does not require the land or require the value of the land, they will have to pay the value of the land.
Yes, sir.
Then only.
Yes, Your Lordship. We look at
The moment they indicate, we'll deposit the money.
That's it. That will.
just 4 weeks time may be given for today, Lordships. We've seen Your Lordship's order of January. So we're aware of what has fallen from Your Lordships. We'll take instruction.
Is there a committee appointed?
Yes.
There is a
There is a high-powered committee.
Heard us also, and then.
So the order said that you will be heard in that
Yes,
committee.
Your Lordship is at high-powered committee and there is a high-powered committee looking into it. Just 4 weeks time, Your Lordship will grant us.
That's 4 weeks more time for taking a final decision in favor of order dated 15th January 2026. In order to strengthen the hands of the state government, we have we reiterate the important intent of our order dated 15th January 2026 that the state government shall have free hand in determining the
compensation
actual market value of the land, actual market value of the land, which the petitioner shall be obligated to deposit as soon as it is demanded.
Yes.
As soon as it is demanded. So similarly, if the state government requires a parcel of land for any public purpose, the petitioner has also undertaken to pay the sale price of any such land that may be identified by the state government. That may be identified by the state government. We have no reason to doubt that in light of the above stated fair offer made on behalf of the petitioner, the state government shall take a positive decision and apprise the court.
Your Lordship will not say take a positive decision. Your Lordship will say consider it, Your Lordship. That's our only request.
Shall take a reasonable and fair decision.
Most grateful, Your Lordship. I'm sorry, Your Lordship understands my position.
Just want to indicate a fair.
Yes, no, we'll definitely convey what has fallen from Your Lordship.
Council
It's
on
just that,
the side, it will be a reasonable decision is what the court is indicating.
no, for sure, my senior is on the other side.
You being there as a communicator of our order, we have no doubt that.
Yes, no, Your Lordship, we'll communicate it appropriately. Most grateful.
The letter.
I'm going to go.
There is a letter here, I think. 25 also. 26 also.
There is an interim order up to date,
Entire model to continue, wherever.
My lord, in 25, I am for R5 to R8, my lord.
I think 27 also.
25, my
My
lord,
lord,
kindly grant
intent-
permission to file additional document. 25, my lord.
Wherever 25 additional affidavit can be filed meanwhile.
To file additional
My
document.
lord's item 27 letter is,
Item 27 also there is an affidavit.
my lord's interim order to continue. My lord's 27 interims to continue.
26 also there is a letter.
We need some time for that.
But we need, I have
Yes,
a
my lord.
team a lot. We need 4 weeks time
It's
to
a letter.
But we never got the.
26, there is a letter.
26? Yes, there is a letter in 26.
There is a letter in 26.
Lord,
Yes,
we may grant it 4 weeks time to come to Lord. I appear for ED.
My counter affidavit to file.
And my lord, 2 weeks thereafter for me to rejoin them.
All right, counter affidavit to file within 3 weeks. So rejoinder filing within 1 week thereafter. Post the matter after 4 weeks on so date. Item 27 also there is a letter.
Yes, my lord's interim orders to continue in that. That's the interim orders to continue.
Interim order to continue. We
Grateful.
never grant up to the date. We are waiting for the.
Grateful, my lord.
28, my lord, had issued notice. No one has entered appearance from the union side.
Letter for filing counter, 20.
27, my lord.
27.
My lord.
You have ordered 28.
27.
20, you are on 27.
Interim orders,
4 weeks time is granted.
yes,
to file.
interim orders to continue.
Post 28.
Interim order to continue. Grateful. Grateful.
Item 28.
28, my lord, no one has appeared or entered appearance or filed a counter from the respondent side.
29.
Please, your lordship. This one, no one has appeared, entered appearance or filed a counter from the respondent
Was
side.
issued on May 26.
Yes, my lord.
Service is not complete.
Service is complete, your lordship.
Postmaster, any notice report about service?
This is pertaining to the wetlands.
When did it get complete? Kind of.
Office report says it's complete here.
It's Union of India and National Wetlands Committee. Normally somebody is on record. That's why.
Please, your lordship.
Well,
if we may serve through, someone.
Let the office of, let a complete set of paperwork be supplied to the office of Solicitor of India. Or you, why don't you accept? When say, the National Wetland Committee appears to have been solved. No one has entered appearance since the Union of India, that authority was constituted by Union of India.
It's also respondent number one. Just contact.
Union of India is also respondent number one. We have requested Mr. Anand Kaushik by the District Solicitor of India to accept notice on behalf of the respondents. That a complete set of paperwork be supplied to him tomorrow. Affidavit will be filed within 4 weeks. Most the matter on so.
Great.
Please, my lord.
Grateful.
Your lordship, on last hearing, there was an order to tag this petition with writ petition 471 of 2026. But the order doesn't show that tagging order.
That's it. It is to be tagged with
Writ petition 471 of 2026.
471
471 of 2026.
tagged with.
471, Lord, is the first petition on this very issue,
Hardly
which your
found
lordship
it.
had issued notice on 20th of May. And in that order was for listing today. Unfortunately, it is not.
So the order said 10th August.
Yes.
They are not.
Yes, in that matter, order said 10th of August, yes.
What is the any date in that case also?
My lord.
No, Lord, that today was the date, but it is not listed.
When I tag with file your counter affidavit.
Millards, I am appearing for state of UP, Millards. My appearance may be taken.
Also, those who have entered appearance by their pledges, counter affidavits be filed within 4 weeks. No further adjournment shall be granted. The service is complete or?
My lord, service is complete, but only 2 states have filed the memo of appearance, Maharashtra and Mizoram.
Liberty is granted to the others, Himachal also. And
Yes, sir.
liberty is granted to all the states to enter appearance and file their respective counter affidavit.
My lord, grateful.
And tag with 471, Lord, 26.
471.
471, 26, that's the first matter.
My lord.
Same order in 471. This order rather will be in 471.
So great. So,
My lords, in this, yes, my lords, I'd mentioned it in the morning. The learned solicitor is leading us, so next week, if my lords may take it on Monday.
So these are the matter where. When do you want them?
My lords may take it anytime next week, my lords. The solicitor is back.
Next Monday.
Very well, my lords. My lords may have it on Friday, if possible, next Friday, if possible. We'll file our status report.
They always remain.
Very well, my lords. Monday, no problem. Great.
24.
After getting an order from here. Who's appearing?
R2, R4,
Himachal.
Himachal not required to be served. Yes, item 34, 34. Mr. Advocate General, are you?
Yes, Your Lordship. We are appearing in this matter, Lordship. My lord, we have transferred these 3 officers, Lordship. So they are transferred now, my lord. 3 applications are moved in the High Court itself for modification of the order which is assailed here, Lordship. Even state has also filed an application explaining all the facts before the Honorable Court, Lordship. That is, those 3 applications are pending.
Then we can dispose of this matter.
Subject to what petitioner says, because yes, if those applications can be considered there, Lordship, and that because my lords have stayed the SIT and
to consider those applications sympathetically.
Please, my lords.
Pass appropriate order regarding this FIR business. Rest transfer has been effected.
Please, my lords, transfer has been effected, my lords, or my lords can
take this matter after a few months, because by that time disciplinary proceedings will also be completed. And I can.
This be considered by the High Court because the state has also made applications for modification of the.
Yes.
Please,
Because
madam.
there are differences. One is music fest in a tourist state and another is drug menace that we are tackling in the state with at large scale, Lordship. So the music fest activity has to go on, Lordship.
Your action must inspire confidence of the High Court that
Yes,
you
sir,
have taken actual steps to tackle the drug
Actually,
menace. This belt is particularly, unfortunately, lot of infliction.
Please, Your Lordship.
Mr. Advisor, what really weighed with us is a DSP report not recommending the holding of the festival there
But
because of the nature of the terrain.
please, Your Lordship.
So that was glossed over. So whether you can allow your economic interests to override law and order.
Yes, both are to be
Right.
taken into
But the
consideration.
challenge-
Yes, Your Lordship.
Now, when a DSP says that this terrain is of such nature, our policing is difficult, the SDO should have taken into consideration.
Yes, sir. But the wrath was on the police department also because SP was also ordered to be transferred, whereas he has reported that.
SP was ordered to be transferred is because SP sat over the DSP report and gave the public.
No, but SP said, yes, our DSP is saying that it cannot be ruled out. So, it's whatever, if the High Court may see it, yes, Your Lordship. High Court may see it, till then that interim order may continue with respect to FIR
Yes.
and SIT.
Please, my lords.
Issues are directly requested in interlocutory order. Past 50 months are directly requested an interlocutory order passed by the Government of the High Court of Madhya Pradesh. Directing one eye. Also, the officers from District Kullu. 2I, initiation of disciplinary action as in term. 3I, also registration of FIR and constitution of SIT for such for investigation. While our interlocutory order dated 27 July 2026, the last direction, re-registration of FIR and constitution of SIT was given. So far as, next paragraph, so far as transfer is concerned, the Advocate General in Madhya Pradesh states that the directions have been implemented.
Yes, sir.
And all the officers have been transferred.
Yes, sir.
Next paragraph, these two postings are still pending. Next paragraph. Learned Advocate General further informs that the state of Madhya Pradesh as well as some private parties have moved applications before the High Court for modification of recalling of the interim order dated 24th June 2026.
Please, sir.
Those applications are pending before the High Court. Next paragraph.
But we have also placed on record some special operating procedures with respect to these music fest in these areas. So, those may be considered.
State government is also appears to have placed on record before the High Court the issues taken by
SOPs and steps taken. SOP guideline frame for this lot.
operation procedure as well as the initiative taken to tackle the drug menace.
Please, sir.
Yes, sir. Next, I review the fact that the High Court is seized of the matter from our disposal of this special research to, with a request to the High Court to consider those applications. Consider those applications sympathetically and pass appropriate.
Please.
I'm so obliged.
Please, Your Lord. By the interim order passed by my lord, that may continue till the disposal of.
Prior matter will come. The interim direction regarding interim directions for August registration of FIR or constitution of SIT are our made up.
Please, sir.
Operate in the matter decided by the
Please, Your Lord. Deeply blessed.
Item 35.
My lords.
On the last occasion, my lords had indicated that Mr. Datar is Mr. Datar is leading me in this matter. On two earlier occasions, my lords had directed the various high courts to place on record their report, asking them to place on record.
Commercial code.
Yes, my lords, regarding the Commercial Courts Act. Now, my lords, we have done a comparison of all the reports that have been placed on record, and we have found that some of the high courts have currently not been able to. Mr. Datar is.
I think my young friend is presenting it much better. Let me continue.
The young member of the bar is doing very well.
My young colleague is presenting it very well. Let her continue.
Yes, yes.
May I, my lord, hand over a comparative chart that we have done of the status that has been presented by the respective high courts?
Give me a copy, please.
You have included up to date or earlier the data is only available till 2020.
We have, my lords, still there were two orders that had been passed by my lords, by which the high courts had been directed to place the data on record. When we reviewed the affidavits filed, we noted that some high courts are yet to comply with the second order passed by my lord. We have tabulated it such that we can identify the points that were required by this honorable court to of the high courts and with reference to the respective sections of the Commercial Courts Act.
Is there any evaluation that based upon the total pendency of cases or the trend of cases, that how fast, how many cases have been filed under this act?
My lords, that information in fact has not been placed on record. In fact, by way of my lord's order of April 2025, that was a specific query that was put to the high courts that at least identify the time that is being taken.
Do this also,
My
this exercise,
my
that what is the trend of commercial litigation, growing trend of the commercial litigation in different states, and keeping that estimated requirement in mind, how many courts in a phased manner are required to be established?
My lords,
With one direction, establishment of entire courts may not be feasible. It all depends upon infrastructure, availability of officers. But this is a process which should be taken care in continuous basis. So prepare that based on that data, and also indicate that in which state, how many courts are right now immediately required to be. After all, we cannot afford to have a long areas also in these courts. So maybe in some of these states, some immediate direction will be required that they need to establish. So we will largely rely upon what the data and the facts and figure you will give.
My lords, will place that on.
These states are also party here.
States and High Court both are parties.
In fact, my lords, earlier directions had been issued to the high courts only to respond instead of.
Please.
I think the states should also be included because
My
when
lord,
the
states are
question of
included.
establishment of courts will come.
Yes, my lord, that's.
Mr. Datar, don't you think that states should also be called upon?
Yes, Lord,
My
absolutely.
lord, states are party.
Lord, what's happened is.
Along with the High Courts.
Yes,
Notice
only to High Court. Please, Lord.
But the whole idea of commercial court is to expedite the hearing. But if that is not going to be answered, because that the whole thing, a part of ease of doing business is how far a commercial decision is decided by the courts. That was the very logic in which we started commercial courts as a departure from the ordinary civil courts. So a lot of changes were made. Yes. What should we call it?
The High Court will also depend upon their states for establishment of additional courts wherever it will be required.
Yes.
So by the time that this information is collated and if the case for issuing direction for establishment of additional courts is made out, then better the states are also present so that we can direct them.
And Lordship is right, it will vary from state to state.
Exactly.
Necessarily will vary from state to state.
In some of these states where you have more cosmopolitan or urban major cities, there the commercial litigation might be
Higher.
growing with a fast speed as compared to other states were dominated by rural areas.
Yes. Yes.
Going by the definition, comprehensive definition of commercial disputes, I think that might be the trend of the litigation.
Absolutely, my lord. Lordship is right. Lordship may call it after 2 weeks, my lord. We'll just see what the progress is.
We can issue notice to the state meanwhile and
Let
say, when counsel for the petitioner has placed on record the relevant information in a detailed, in a tabulated form, depicting the number of pending commercial cases as on 31st January 2025 and the corresponding infrastructure that has been provided for the commercial courts. It seems to us that the information needs to be updated at least as on 31st January 2026.
My lords, the information is not as of 31 January 26. It's of 2025, 31/3/2025.
Needs to be updated.
Yes.
We are saying that it needs to be updated.
It's true.
It
My
will be
apologies.
updated as on 31st January 2026, along with details of the additional, along with the details of the infrastructure that has been provided so far. We have also impressed upon the counsel for the petitioner to collect the data with respect to the growing trend of commercial litigation statewide and to have an estimated requirement of increased commercial courts, a requirement of additional commercial courts in such states, that information may necessitate to issue appropriate directions for establishment of additional commercial courts. Next one. In this regard, for the purpose of establishment of additional commercial courts contemplated as contemplated above, the presence of the state governments is also the presence of the states governments is also. It is necessary to ensure the presence of the state governments. Let therefore notice be issued to all the states who are already included as party respondents, returnable on so date. These states may be served to the standing counsel in the Supreme Court or to their respective advocate. Post this matter for further consideration on so dates.
Lord, with your lordship's kind permission, can we they have prepared a very detailed compliance chart with granular detail. Can we send this also to the high court so high courts can respond?
Yes,
very granular table is given. Either we can give high court wise or we can give the
information collected by the learned counsel for the petitioner in the tabulated form is taken on record.
High courts are represented.
Yes. Do you have a soft copy of?
My lords, I do. I will file it.
Let me soft copy for the registry.
Yes.
The registry directed to send a soft copy of the information of the information in tabulated form to all the high courts, seeking their response on the date fixed, before the date fixed.
deep level.
Much.
Thank you, Sir Datta.
My lord, pleadings are complete in this matter. It will require some time. May I request for a non-miscellaneous?
I appear for the High Court, my lord.
In some fixed date, my lord. Obliged.
Disability.
May I please.
Lordship, may I submit in item 37?
Yes.
Yes, Lordship, the only point of difficulty in item 37 as of today it stands is the Common Law Admission Test Consortium of NLUs have issued the application form and the notification for next CLAT cycle on 22nd July. But they have neither issued the revised instructions for persons with disabilities, nor in the application form, the ability to give exams on computer is incorporated. It only asks you to fill the details of the, to select the mode of giving exams through scribe. So those are the only two directions that we are seeking through my lords. That one, they should be directed to issue the instructions along with the application, which has now commenced on 3rd of August. So now, since that deadline is passed, obviously they may be directed to do so in a week or two, as my lords deems fit. And second is that they should be directed to include in the application form itself that the persons with disabilities would have mode of giving exam using screen readers, which is currently not captured.
We usually give that notification for PWD candidates. I appear for the consortium, Lords. We usually give our notification for PWD candidates about 2 or 3 weeks after the main exam notification is issued. It is in the process of being finalized. It will be issued in the coming week or next 2 weeks. The exam itself is in the month of December, so there's sufficient time. Last year also, we filed a compliance affidavit.
Should not invite any direction from us. You yourself should voluntarily do it.
Yes, it's being done, my lords, and in fact, last year also pursuant.
Suggestion which Mr. Jain has given today.
Yes, my lord.
Take note and make sure that.
We'll do it, my lords. There's no difficulty. Last year also, all candidates who wanted scribes, either personal scribes or from the pool organized by the examination body, they were made available. Plus, those who wanted screen reader software, that was made available.
Lordship,
There is a procedure, my lords. Every year they update that. The EC meeting has to happen, my lords, because the draft is put up for the.
Make it part of your instructions.
It'll be done, my lords. It'll be done. No difficulty.
Lordship, my only submission
I'm
on
appearing
this
for
is that
the Department of Empowerment of Persons with Disabilities. We had a comprehensive revised guidelines on 1st of August 2025. However, that is on hold further now because there is a wider stakeholders consultation which is going on, my lords. So, my lords, we will come up after a revised guidelines. We'll come up after that consultation is complete, my lords.
And in
Lordship,
fact, that
irrespective of. Yes, Lordship, irrespective of those guidelines, the 2018 guidelines itself contemplate issuance, the giving exams through assistive technology. So that guidelines really would not have much bearing on this issue.
That's not there. If they update the guidelines, it is always better.
Yes.
Those guidelines are for the competitive examinations as a whole, my lords.
Yes,
Lab
Lordship.
exam guidelines will be now issued.
Yes.
Court's direction.
Yes.
They're also anxious. You should let them know in earliest.
Lordship, it should be made part of the application is my submission. As in when they release the notification for the application is my submission.
Whatever issues have been raised on behalf of the petitioner will be effectively addressed. It will be effectively addressed for the next examination that is likely to be held in December 2026. Let a comprehensive SOP, stroke instruction, examination instructions be issued by the consortium in this regard, and a set thereof be placed on record for our consideration. Next paragraph. The way learned additional solution of India, representing Union of India, Ministry of.
The Department of Empowerment of Persons with Disabilities. Respondent number 1.
Persons with disability states that best guidelines, comprehensive guidelines are in the process of being finalized.
Yes.
For which suggestions from different stakeholders have been invited.
Are being considered.
Have been invited. So let that process be completed at the earliest. Post the matter for further consideration. This in September. And Mr. Counsel, you make sure by September and everything.
We'll do that, Melody.
Let's for consultation, we have given an outer limit till 31st of December 26th or earlier. If those are complete, we'll come out before that as well. I'm grateful.
Lordship, anyways, those guidelines deal with public competitive examinations. Here we are on postgraduate examination for common law admission test. So those guidelines are different.
Those are comprehensive guidelines for the competitive exam as a whole. Of course, there'll be certain guidelines which will also be helpful if, my lords, a wider guidelines say that scribe can be used or there's a particular way that it has to be done, that can also be taken up by
No,
the
I'm
CLAT
not saying.
as well.
I'm not saying in an
These are
adversarial manner. I'm not saying in an adversarial manner, ma'am. only I'm submitting is that those guidelines relate to public examinations, whereas of competitive nature such as UPSC, etc., which are for recruitment. This is pursuant to the Prevention of Unfair Means Recruitment Act, basically. But these guidelines are already sufficient enough to cover educational institutions such as consortium of NLUs. So
let us see that guideline.
yes, yes, Lordship.
I'm
Yes,
grateful.
Lordship. Grateful, Lordship.
Item 39, there is a letter circulation. 38 and 39, yes, the board.
Right, please, Lord. This is a Section 11 petition. None appears despite service. They are contesting in the Section 9 before the High Court. The agreement cannot be disputed. The defenses which they are raising, Lord, are purely within the domain of the arbitration tribunal. Because now your Lordship is aware only the existence has to be seen. So my prayer is, my Lord, that the arbitrator may be appointed, and whatever defense they have as to whether they are the successor of R1 or whether they have purchased these assets encumbrance free can be decided by the arbitrator.
Assets of R1?
That's their case. According to us, they are the successor entity of R1. According to them, they have only taken over the assets free of encumbrance. Now, these are disputed questions of fact which will lie within the domain of the arbitrator. And next year,
9, they are appearing in the High Court.
yes, respondent number 9 is appearing, my Lord. Please have page 422. That is the reply filed by current respondent 2 before the High Court. So they are aware of these proceedings. Their stand is like akin to Sarfesi.
Number 2, unfortunately, you not served.
Oh, I'm so sorry, my Lord. My Lord, can I be permitted to serve them in the ongoing proceedings in the High Court?
To the local council.
Yes, my Lord. We'll do that.
As per the office report, service on this committee is incomplete. Let the said respondent resolve to the council representing the said respondent before the High Court.
I only request is, since it's an 11, if your Lordship would be pleased to have it at a short convenient date, I would be obliged. The agreement is admitted. Obliged. Lordship, please.
This matter has been settled, 41. MA number 181543 has already been filed, in fact, by the petitioner.
Well, as I appear for the petitioners in the matter has been settled.
The Army Council is on VC.
And at page number 12.
Whereas the matter has been settled, I appear for the petitioners, matter has been settled, my lords, may be dismissed as withdrawn in terms of the settlement.
Jointly state that the dispute has been amicably settled and thus the President arbitration to dismiss every draw. Forward according.
Grateful for the nudge that came from the Honorable Court that resulted in the settlement.
My lords, in terms of the settlement agreement, if my lords can be recorded that one line.
I'm saying that the parties shall abide by the terms and conditions.
Deeply grateful, my lords, deeply grateful.
Obliged.
Item 42.
Please, my lord. I appear for the petitioner, my lord. Respondent number 1 has filed a short reply. In paragraph number 4 of that reply, my lord, they say that I filed a composite petition. However, my lord, when they respond to my petition in the High Court, at page 241 in paragraph number 4, the same respondent says it's an international commercial arbitration.
Who's for the respondent?
So is item 42.
Lord, I appear for the petition. Mr. Vishal Arun Mishra has filed the response for respondent number 1.
So again, I think respondent
2 is unserved. Respondent number 2 has not been served, but there is a reply from respondent number 1.
Yes, ma'am.
As per the office report, respondent service on respondent is incomplete. Then same order procured. Maybe served through.
Lord, in 45, there are 3 IAs. 1 by us, we are the original petitioners, and 2 by people who are frustrating the High Court from hearing the matter. Just see the last order which the High Court has passed in our IA, my lord. The IA by GWA. If your lordship will see that IA,
my lord, the IA,
the order is at
appearing in the
366.
relief, my lord, can't be granted in this.
No, my IA is also there.
On multiple occasions.
We are also the applicants.
Just see that order which you are, which.
Still pending before Justice Bambani.
Yes, the whole idea is to somehow ensure that he doesn't hear it.
If my lords may
Day after day, my lord, dates are being taken that we are going to Supreme Court. And Supreme Court is going to further clarify something, and that is why they are not permitting that hearing to go on. And they are repeatedly coming here only to frustrate that hearing. Only the whole purpose is to just see his last order, my lord.
I have one additional point I want to make, my lords. This is a blatant attempt to interfere with Justice Narasimha's proceeding, where he has reserved orders on an appeal as to whether the CIRP order, admission order, should be recalled on grounds of fraud. In order to get some observation from your lordships that they can then place there, they haven't filed written submissions as required within 1 week by his lordship's order, by his lordship Justice Narasimha's order. So, my lords, I represent a home buyer, my lords. There are 1,091 of us. My lord, the Chief Justice, has been very vehement about, my lords, protecting the rights of cheated home buyers. We've been cheated twice. First,
Lordship, I am for the IRP. Now by the
which went into insolvency. My lords, 1 minute, my lords.
But this was
Three
listed
went
for
into
one
insolvency, which led to this. The allegation by ED is that they've siphoned off money. Now, my lords, Oris was the landowner who signed all the documents, took 196 crores, and now they are trying to deprive us of our flat.
This was
90% of the first phase was constructed. They've taken orders, my lords, from the High Court saying that all flats to be given only to Oris buyers.
I am for the IRP, Lordship.
Where your lordship should order a CBI investigation.
Well, this was only listed for appointing monitoring authority as per the direction of this court.
Oris has also been declared to be a financial creditor.
Can I support them?
The builder is declared to be a financial creditor.
I need to proceed. We are for the applicants just because.
Can I support the applicant? Can I support the petitioner that side? Just 1 minute. Then the respondents can argue. I am a supporting person to supporting to Mr. Vikas Singh Krishna Venugopal for this reason. I'll take only 2 minutes. Please see the impugned order. My Lords, the Honorable Supreme Court passed an order of 10th of April to 2026 at page 33, relevant values at page 34. There was a clear intent of my Lords that it will go back to the High Court and they will determine who are the home buyers who fall into this category, and then further proceedings will be taken. Now, well, the impugned order, which so-called impugned, which my learned friends on this side are challenging. Once, let me finish, please. Yes. Is a cry of anguish by the learned High Court judge. Just see 2 paras of that. What they have done, my learned friends, both sides of
No, but that's absolutely wrong.
Allow me to finish. Please allow me to finish. Allow me to finish.
This is not a question of finishing. You are on a wrong.
I don't understand this. I'm in the middle of a sentence. By out shouting, you can't hide the truth. I'm reading what is written. Please turn to para 2, but page 316. Page 316 of, yes. Para 5 onwards. The prayer in the miscellaneous application filed there is to
Where are page number?
give the page number.
This is in our IA, Lord. GWAIA.
Allow me to finish.
47940.
Chief Justice has told you, allow me to finish. 317 of Mr. Vikas Singh's IA. GWA. Give the IA number, please. This is not the way the High Court is to be short-circuited after my Lord's mandate.
Well, that's misreading of the application.
Let's read now.
Yes, go ahead.
Page 317, relevant part. Yes. Relevant part only.
The order of 3rd August you are.
That's correct. That's correct. I'll just read without
just read my order, the 4th August order, which I wanted to show.
The prayer in the miscellaneous application filed before the Supreme Court, a copy of which is appended, reads as under. They give the wrong application to the High Court judge. They give the wrong application to the High Court judge. Defer further adjudication of the present matter as an application seeking clarification of the order of 10th of April, that is my Lord's order, presently pending. 6. Evidently, the prayer extracted above is erroneous, considering it has been made before the Supreme Court of the miscellaneous application as per the copy of the miscellaneous application appended. Then, Malas, regardless of the prayer, Mr. Mathur submitted that the court may note the fact that the applicant has passed the said miscellaneous application and may pass appropriate orders. Learned counsel, read 8, Malas, 8, para 8. Learned counsel appearing for other parties, including GWA, that is Mr. Vikas Singh, and the Directorate of Enforcement vociferously opposed the prayer, submitting that quite apart from the fact that the prayer in the copy of the miscellaneous application makes no sense. It's a wrong application filed. Nevertheless, the filing of the application for the Supreme Court is intended to only stall a further proceeding, which is undesirable. Upon this being pointed out, Mr. Mathur, who is for the side who filed the wrong application, gives the correct application, which is today listed. My Lord has got this para 9 application listed today. This is the current
Querying for that.
correct,
I'll
correct
clarify
one.
this
Yes.
position, Mr. Singh.
The different copy of the miscellaneous application is taken on record. Now come to 11. Clearly, the prayer in the application filed before the Supreme Court is to seek a direction that this court may not only defer restitution or disbursement of the proceeds of assets and appoint a former judge of the Supreme Court as monitoring authority. On the other hand, in the present application, prayer is to defer further adjudication. On a combined reading of the prayers in the present application, the miscellaneous application, this court is unable to decipher exactly what the applicant, that is people on my side, Kusum Dwivedi. It may be recorded that this bench was in session of the present batch of matters. He has had 14 hearings, the learned judge, and is about to decide this matter of who the home buyer after 14 hearings. Under Supreme Court directions, upon change of roster, it is placed back before him. Ignore that. Come to 14. Counsel for ED, GW and other parties have expressed their unreserved stand that this bench must continue hearing the matters. Everybody, except Ms. Kusum Dwivedi and one or two others. Mr. Kunal Tandon, learned counsel for the promoters of 3C, also states that they want the matters to proceed. As a matter of fact, at the conclusion of today's hearing, Mr. Tanmay Mehta, learned counsel appearing for GWC, that is Mr. Mehta is opposing Mr. Vikas Singh, also says that they are desirous that the matter be heard before this bench. In these circumstances, Mr. Mathur, learned senior counsel, appearing for the applicant, seeks time to take clear and categorical instruction. Now turn
And the next order.
Next order.
Next order is very important.
Right, next, immediately after this, come to page...
Starts at 325.
325.
325. Fourth.
Yes,
Fourth.
that's the next one. At yesterday's hearing in the present batch of matters, Mr. Counsel appearing clear instructions, leave that one, come to para 3. By way of the present application, Kusum Dwivedi says, defer further adjudication. This is a kind of a game going on, Malus.
It's absolutely...
No, please see after.
This is absolutely wrong. Kindly see...
Para 4. The moment
kindly see the application which is already on record.
Please don't interrupt me.
Kindly
para 8.
Para 4. Before attempting to understand that the applicant wants by way of prayers, it must be observed that a copy of the miscellaneous application was appended. Then, Malus, subsequently, learned counsel informed the court that the copy so appended is not a true copy, etc. Leave this.
Go to para 8.
This was on the same
Now
day.
come to para 8. Para 8. Para 8 is most important. This court is constrained to observe in the course of hearings over the last several dates. This court has got the clear sense that there are divergent vested interests at play in the present matters. After my Lord's order, some of whom appear to be interested in derailing or prolonging any effective orders being passed in the present case. Accordingly, this court would view the present with requisite caution. Considering the evidently contradictory pleas taken in the present application, the application filed before the Supreme Court, before proceeding further with the matter, the applicant Kusum Dwivedi is directed to file an affidavit clearly stating her locus standi.
And then
She pops up as one home buyer.
I am appearing for...
Let the
I must make given a chance to clarify.
After I finish.
Please give me...
Furthermore, it is observed that as recorded in the order of 30th July, Mr. Aman Lekhi will continue with his submissions. However, Mr. Lekhi was not present on 3rd, nor is he present today, nor is any other counsel present on behalf of COC. Now, Maharaj, how does a judge carry out the mandate of finishing if I don't go and argue?
And your lordship is being given, in their IA it is given as if he is not hearing the matter.
On my application,
please change the
Mr.
judge.
Singh, we had made that statement with us. On my application as a home buyer to say that, kindly allow me to clarify this position. But if my lord sees by April's orders of my lord, the ED as well as the special court PMLA said that using the provision of section 8 of PMLA, the attached assets of the promoters are to be dispersed to satisfy the claim of the home buyers, which I am one of the home buyers. Court said that please, initially the judge was appointed and thereafter was withdrawn. Later on, this in the application came, my lords, of the order of 10/4/2026 noted that the ED also said, and we also said, please appoint the monitoring authority, some judge of this honorable court, my lords. We said, my lord said that the High Court consider and decide them that. That's the order on page para 8, which has been done. This is the application I filed. This is the position I have taken before the court that since the assets are there, ED has confirmed this position. Special court has agreed with that position. Please appoint the monitoring authority. The challenge every time from them is on a one pretext or the other that these assets should not be dealt with. All today I'm making an application with instruction, my statement may be recorded, that any monitoring authority may be appointed to deal with them.
Lord, may I just point out something?
Today, one application or the other, my lords can see that there is a bloodbath going on the
They
other
are
side.
filing the application.
Nobody is going to get any
and
asset.
not letting the hearing go on.
Averse to appointment of any monitoring committee, but let such a decision be taken by the.
Look at the situation today before my lords. Look at the situation, my lords. There's a competing interests which are there. They may be vested or not vested. I'm not casting any aspersion against them. Any authority who can look into it, all I'm saying, because this exercise it takes 9 hearing it takes this authority 9 hearing it takes that today we can't reach a point. Somebody can
Please see all the hearing dates. Every date they have delayed.
They want nobody else should speak. Nobody else should speak, and they should get and prejudice the court on one aspect or the other. All I'm praying before this honorable court, any authority may be appointed that's going to assist the court, so that the claims can be examined.
Mr. Bulbir, let the court take a call on it. Require the assistance of a monitoring committee, the court will constitute that committee. If the court requires assistance of some other domain expert, the court will.
Absolutely. With so many
people should.
Can I just? I am for the other applicant.
Your lordship can say day-to-day hearing, Lord. We are ready to.
All the parties on 24 consented. We consented on this aspect, all of us at that point when this order was.
Can I please be heard before them? My turn. I am for the applicant. My lord, Mr. Singh and Mr. Venugopal won't allow us to argue. Lord, my submission is very simple.
My lord, may I submit on behalf of?
Lord, my point is this.
Mr. Raju is also there for ED.
Lord, today the point is this, that certain assets of the defaulting promoters who admittedly siphoned off the money have been seized by the enforcement director. Who that money has to come back to is a different question which is under adjudication. Why should those assets not be monetized in a pool for all home buyers? Mr. Singh's client, Mr. Venugopal's client have been obstructing the appointment of...
No, there is no obstructing at all.
Absolutely not fair.
I think the ED will answer this question better.
Let that money
I think Mr. Raju will answer this question better. Whether that...
There's a dispute.
No, we want to. We want to.
My lord, I have not been...
We are compelled to file the application only to bring the subsequent orders on record.
I'll explain why.
Yes.
I'll explain why. My lord, every time the matter comes up before the High Court, after your lordship's order is shown and the ED suggestion is made, Mr. Singh's and Mr. Venugopal's clients say we are opposing this for the...
No, never. Just read the order.
Precisely, that's the...
Just allow me, my lord. They are opposing restitution.
If they are opposing, ultimately for the just to take a call.
Decide.
Lord, that's not... Just let me explain. My lord, what they are opposing...
They will eventually...
If you come here with an SLP, how will the case get over? It's listed on 13th August. You don't argue on your case. All your problems will be sorted.
Our trepidation is that they are not allowing the hearing to conclude one way or the other.
Court not control. This is also it's a High Court.
Lord, I agree, but our trepidation is why should money siphoned off?
File an application here because somebody moved an application.
No, they are only moving application. Lord, they are only moving application. They are seeking adjournment and now coming here and saying that the matter is not going on. Just read the entire order sheet. I can read the all entire order.
Problem if cheated money is put in a pool under the supervision of...
That's precisely the point.
Let's just see.
We have no difficulty with that, but that is only a purpose to derail that proceeding.
That cannot start the proceeding.
I have a suggestion.
I think Mr. Raju can answer that point. ED proceedings are... Mr. Raju is also having a problem with the judge's order. They have also challenged that order. If he's permitted to argue...
In this
in the High Court, outshout the learned senior. I have a suggestion.
Mr. Raju's voice is...
Am I audible, my lord?
Mr. Sadhu, do you want to say something additional?
Yes, my lord. I want to say this, my lord. First, my lord, direction should be given to the learned judge in the High Court to decide the matter as soon as possible, preferably within a time-bound manner. 1 week or so. One. Secondly, my lord, as far as ED is concerned, ED is not concerned with the properties of the company. This is properties of the promoter, which is outside the purview of the resolution professional. I don't want the IRP to intervene, my lord. I have doubts about the integrity.
I'm here.
I'm here. To monitor the entire thing, including adjudicating who are the genuine home buyers. If the IRP steps in, it is going to be a chaos, and it is unwarranted persons and persons who don't deserve will be given the money which I don't want. I want a retired judge of this honorable court monitor who are the genuine home buyers.
Genuine
Because
home buyers, only that question.
a large number of home buyers are propped up by the builder, my lords, which I don't want.
Whom they are representing.
And if identification is a problem, therefore a retired judge of this honorable court must decide who is to get the money.
The home buyer.
They are not allowing the high court to proceed, my lord. Every day there's a ruckus in the court.
You may just bear with me for a minute because Mr. Raju has raised a point on the IRP. I just need to 1 minute. No, let me address the court, please. Lordship, it's as follows. This IRP, for whom I'm standing, was appointed by an order of the NCLT, and the direction was verify the claims. The problem with this particular case is that it was a collusive proceeding started CIRP by the ex-promoters who took the money, siphoned it off, and then disappeared. And then somebody propped up and immediately admitted the claim. At that point, there were 2 IRPs changed. This is the third one. The third one came, he was directed, please do a verification of claims. 3 reports were submitted. That challenge to the verification was rejected by the NCLAT.
No.
1 minute. I am addressing the court. This is not fair. I am addressing. No, I will. Lordship, I am not saying anything incorrect. I'm sorry, Lordship. I will not say anything incorrect. I owe it to the court. I don't owe it to any of the claims.
No, you are being dishonest.
No, I'm sorry. I'm not dishonest, Mr. Singh. And this is not fair.
He should act.
This is no. The challenge to the verification is an order of the NCLAT which clearly rejects it. Now, there are 2 home buyers here. There is a GWA, which is an association, Greenapolis Welfare Association. There is a GWC, which is a Greenapolis Welfare Confederation. Now, in between, just bear this in mind, these 2 are fighting with each other. To cut a long story short, there are 3 status reports, including the verification, with no cooperation from the ex-promoters. Whatever was there was placed before the court. Now, thereafter, the matter came before this honorable court. This honorable court, in continuation of the CIRP proceedings, directed the NCLT to look at the complaints on the IRP. That also has been adjudicated.
No.
Yes, it has been. There is an order. Lordship, it's an order of December 2024. I'm sorry, Mr. Singh is not instructed. Note of the ED, which says, just last 3 sentences, press note of the ED comes out for restitution of assets. The IRP is before this court says, yes, I'm giving my undertaking as per the press note that the restitution should be done. The issue is restitution. The challenge here is that when the IRP files for restitution, one set of home buyers files a contempt against me. When he doesn't move on restitution, the other set of home buyers do it. These are competing interests. The court has to decide. Lordship said for a judge, perhaps that's the best way.
Because this IRP is in contempt. There's a judicial order saying that he's biased.
He's colluding with the builder.
He's colluding with the builder.
And
the NCLT has found, my lord, the NCLT has found that he is colluding with the builder. He's made the builder, my lord, as a COC member. Builder, 80%. 80% is honest according to him. And he's trying to defend the home buyers. He says, and all the home buyers, not the genuine home buyers of 13, have been rejected by the IRP.
Notices have been issued against him.
That ED's prayer.
It's correct, Lord. It's correct, yes. That should be done.
That's about the.
Let the home buyers submit a retired
GWA is a front of the promoters.
Who is the genuine home buyer? Let it be decided by a Supreme Court judge. We have no difficulty.
Well, that's all we are saying.
Not everybody.
What ED is saying.
Just one request. Direct Justice Bambani or request Justice Bambani to hear this matter day to day at 3:30 p.m. and finish the entire batch, my lords. That's our request.
That will be best, yes.
Even that's what I said.
And in the meantime, these claims can be verified by the.
These applications have been moved for clarification stroke modification of our order dated 10th April 2026. By that order, we decline to express any opinion on merits of the allegations or cross allegations made by 2 sets of home buyers and thought it appropriate to request the learned judge of the High Court to take up the case for final disposal. The parties were directed to extend full cooperation to the learned judge. Next, it we mentioned that the matter was pending with Justice Anup Jairam Bambani of the Delhi High Court. Various orders passed by the learned judge revealed that despite his efforts being, despite his despite the
Honest efforts
extraneous
made by-
despite the best efforts made by him for early disposal of the case, comma, moving of one or the other application by the contesting parties is creating impediment before the learned judge. Also, in such circumstances, comma, we are constrained to issue additional directions in the particular circumstances, comma, while disposing of these applications, comma, we are constrained to issue the following additional directions. One, we request Justice Anup Jairam Bambani to continue with the matter on day-to-day basis and make an endeavor to decide it finally at the earliest. Two, senior counsel, stroke counsel for the parties are requested to extend full cooperation to the learned judge towards final disposal of the matter. Three, the Justice Anup Jairam Bambani will continue with the matter even if there is a change